tracking the common law, the routine and the revolutionary. Even when it is spoken by a handful of the harried remnants of destroyed communities, a language contains within itself the boundless potential of discovery, of recomposition of reality, of articulated dreams, which are known to us as myths, as poetry, as metaphysical conjecture and the discourse of law. George Steiner. There is no better symbol of the common law's evolutionary quandary than the role of so-called great cases. These are cases, Hadley, Donegal, Hedley Byrne, and their ilk in English private law, and Brown, Griswold, Miranda, and their kind in American constitutional law, that are regarded by almost all lawyers as landmarks of the common law tradition. While their precise import and reach are continuously contested, any credible account of the common law has to be centered upon such decisions and must be able to incorporate their authoritative intimations. However, the very existence of such cases and particularly the circumstances of their origin seem to confound the legitimacy of the process that they allegedly anchor and from which they purportedly arise. The skeptical observer might be forgiven for thinking that great cases appear to be less a continuation of legal tradition and more a break with existing traditions. They tend to exemplify a deviation from existing commitments, not a derivation from them. Great cases represent the impressive pragmatic strength of the common law in being able to adapt to fresh challenges and new conditions. However, they also present jurists with their most pressing jurisprudential challenge of explaining the operation of the common law over time. Mainstream jurists must be able to show that incremental adaptation is not simply a cover for radical realignment and, as importantly, that the balance between stability and change is neither ad hoc nor unpredictable. The balance struck must itself be explained by something other than ideological preference. Insofar as great cases are the heart and soul of the common law, therefore, it must be explained why that common law tradition is considered to extol all the virtues of restraint and caution that the creation and acceptance of great cases so gloriously flaunt. In other words, how is it possible for the common law to be constant and changeable? It is my contention that mainstream efforts to provide an adequate account of great cases and therefore the common law have failed. Indeed, great cases seem to confirm that the common law is more of a political, unruly, and open-ended process than traditional scholars are prepared or able to admit. What is ironic is that, for a tradition celebrating legal order, the common law's sense of its own tradition is attenuated and impoverished. There is little appreciation for the organic and evanescent character of tradition and its transformative possibilities. Accordingly, contrary to Holmes' opinion that great cases, like hard cases, make bad law, I will place the incidence, importance, and influence of great cases at the heart of my jurisprudential project rather than treat them as anomalous occurrences that require special explanations. Once this is done, the tradition of the common law is seen to be less about stability and continuity and more about change and transformation. Beginning from the premise that a tradition is best considered and assessed by reference to its great moments rather than its routine practice, I offer an account of the common law tradition that is intended to be both descriptively accurate and prescriptively defensible. Moreover, when the common law is treated as an institutional commitment to the notion that anything might go, it becomes possible to integrate both the routine operation of the common law and the radical leaps that transform it into one consistent account. Although lawyers and jurists emphasize the routine, it will be the radical occasions of great cases that best capture its dynamic spirit. Indeed, contrary to conventional wisdom, it is the relentless critic who most closely grasps and continues the common law tradition, not the complacent apologist who insists on a timid acceptance of what has already been decided. To treat the law as static or to adopt an unquestioning posture toward it is to betray, not uphold, the common law tradition. The chapter is divided into 5 parts. In the first part 1 explore the canonical nature and identity of great cases. My emphasis will be as much on the circumstances of their emergence as on the controlling influence of their elevated status. In the next 2 parts I look at the function and role of great cases in English tort law and American constitutional law. One underlying theme is to illuminate how the biological debate over gradual or punctuated evolution plays itself out in law. In the 4th part, I examine the traditional defense of the court's reliance on stare decisis and criticize its inability to explain the legitimacy and significance of great cases' birth in the common law scheme of things. In the 5th part 1 pull together the various strands of my argument and deal with certain likely objections to my thesis that great cases confirm the relevance and accuracy of the claim that law is politics. Throughout the chapter, I contest familiar insights and persisting shibboleths about the ordered, incremental, and predictable evolution of the common law. In short, although Wasserstrom intended it in a slightly tongue-in-cheek manner, I want to make a more serious defense of the assessment that precedents ought always to be followed except when they should not. While great cases might well mark the end of an era and the beginning of another, They also represent the continuation of a tradition in which anything might go and in which breaking with tradition is as traditional as it gets. As great cases demonstrate, precedent is not the vital glue of the common law, it is its convenient shell. Canons and cases. Perhaps more than most academic specialities and professional practices, law is very much a canonical exercise. Certain texts and materials are given priority and centrality in legal debate. They are expected to impose discipline and bestow authority on various arguments and outcomes. The traditional basis for this authority is as much institutional as intellectual. Compared with their philosophical or literary counterparts, lawyers and judges do not consider themselves free to go for the best, because they are constrained by history, by precedent, by the nature of legal and political institutions. This reliance on canonical thinking is evident in the training of young lawyers, the work of practicing lawyers, and the craft of judges. The canon-based approach to legal education, law, and adjudication has two distinct parts: the selection and identification of canonical texts and, as importantly, the establishment of a reading method by which to elicit those texts' operative meaning. While the whole idea of canonical readings is absolutely central to the educational, legal, and jurisprudential enterprises, I will be concentrating more on the selection of canonical texts. Indeed, out of all the thousands upon thousands of cases that exist, it is revealing to examine those that take their place as great or leading cases in the common law canon. What they say, why they became prominent, and what they represent are some of the more interesting questions that can be asked of these landmark judicial decisions. Indeed, it is not going too far to suggest that the identity of great cases and the process adopted to confer such an elevated status upon them are some of the best indicators of lawyers' basic jurisprudential commitments. In short, great cases offer a convenient and concise summary of the fundamental theoretical assumptions that underlie the common law. In a very real and important sense, what counts as a great case is simply whatever people agree to designate as a great case. Of course, while some people, like appellate judges, exercise more clout than others in this process, court decisions do not attain greatness unless they can attract a critical mass of support among the legal community at large. There is nothing so self-evidently or intrinsically great about particular cases that it automatically guarantees their inclusion in any jurisprudential hall of fame. While this in itself is revealing, there is nothing about law that is different in this regard from literature or art. This status is as much a matter of communal acceptance as conformity with any universal métier and about the virtues of greatness. To put it another way, the quality of greatness is part of the communal debate rather than an external restraint upon it. In this way, the debate over what does and does not count as a great case is intimately tied to the informing debate over the nature and purpose of law and adjudication. What qualifies a case as great depends on the underlying view of law and adjudication being adopted. Consequently, it seems reasonable to utilize such cases as a convenient and compelling way to illuminate that debate and to evaluate contributions to that debate in terms of their capacity to explain the existence and evolution of great cases. Great cases, like Donegal and Brown, are simply those cases that the legal community continues to consider great. There is little that is intrinsically great about them outside of a particular context or agenda. At another time and in a different context, great cases might become simply run-of-the-mill affairs or, more usually and more revealingly, great mistakes and landmarks of what the law ought not to be. The analogy between the legal and literary community in its adherence to the idea and importance of a canon of great cases and great books is strong and striking. In the same way that literary scholars seek to isolate a small group of texts that are claimed to represent the best of the prevailing tradition and that can ground readers in the core values of good literature, so the select library of great cases is offered as not only relevant in itself but also as the best that the law has to offer. In each case, the values and virtues that they embody are said to have withstood the test of time and distinguished themselves in the ruthless arena of literary or legal ideas. Taken collectively, the canon is treated as a treasured repository of a traditional wisdom that has been passed down through history and that transcends the particular circumstances of its making. By acting as its cultural stewards, lawyers and literary critics give humble recognition to the universality of the human predicament and their own precious but flawed contributions to its resolution. In addition, by attending to these totemic texts of law and literature, both lawyers and literary enthusiasts are supposed to be able to learn that modern society shares its fate and future with earlier generations. Offered as freestanding texts, great books and great cases reinforce the benefits of consistency and continuity. They recommend an unbroken and unchanging tradition of superior insights that is to be presently deviated from at considerable peril to society. However, On closer inspection, these alleged universal verities are revealed to be ephemeral vanities. Whether packaged as scholarly commentary or professional exegesis, these values are often the interested views of privileged local commentators who simply happen to be invested with contingent authority. It is not the fact that the choices are political that is the problem. Rather, the problem is that this partisan politics is unfortunately occluded not only in the name of culture and sophistication, but also in the service of some imagined, overarching, and ostensibly neutral political program. Contrary to the traditional claim that great books and great cases achieve their rarefied status by dint of their own intrinsic merit and cogency, it is their continued compatibility and consonance with prevailing values and interests that gains them entry into the canon. As regards great cases, there are a variety of ways that particular decisions and judgments can come to be considered important or of lasting significance. The immediate political background or social circumstances of the case might make the case memorable. The identity of the parties might be so significant as to warrant notoriety. The judge may have added an especially telling or imaginative twist to the law. The decision could be unexpected or perverse, or the social consequences of the decision might be far-reaching and substantial. While these are all possible bases for marking cases as worthy of celebration or noteworthiness, these are not my concern. I am interested in those cases that lawyers consider to be great. They might well possess some of these features, but they will not be determinative of their greatness. That said, it is not my intention to develop a definition of greatness and then proceed to harvest those cases that meet such criteria. On the contrary, my approach is more deconstructive in that I take what lawyers and judges consider to be great cases and utilize those cases to subvert the stability of the very process that they are said to showcase and ground. I give substance and weight to the non-foundational insight that what is and is not treated as canonical will depend on the purposes of so-called canonization. Because the focus and ambition of lawyers is legal as opposed to political or sociological, it ought not be surprising that what counts as canonical will relate to the operation of the law and be determined by its importance to the law's development as a relatively self-contained and coherent body of norms. Accordingly, those cases that are selected as great say more about the interests and purposes of those who select them than they do about the subjective matter of the cases themselves. Great cases are shorthand symbols for deeper and more elaborate theoretical commitments. Canonicity in law is said to be more about doctrinal integrity and authoritative designation than it is about social causes, political consequences, or aesthetic appeal. That having been said, there does seem to be a general consensus among lawyers on the notion that great cases are those that have become sufficiently and widely accepted over time as being of central importance. Not only must any future development of the law be able to incorporate the holdings of great cases, but also such holdings are treated as capable of pointing in the direction or illuminating the path that such new development must take. This idea of great cases as landmarks upon the trackless wilds of the law or as affixed stars in the jurisprudential firmament gives a sense of the belief in them as intellectual compasses for legal travelers who are uncertain where to turn or go. However, there is a tendency to treat these great cases as more enduring and certain than they actually are. Even stars explode or implode over time, and their fixity is always relative to location. In the traditional vocabulary, this definition of great cases suggests that there is something natural or given about their status and that their identification is more a process of discovery than creation. Again, this ought to come as no surprise. Mindful that canonization says more about those doing the canonizing than that being canonized, the depiction of great cases as found objects that orient and guide the humble lawyer reflects important underlying assumptions about the nature and development of the common law. That is, it is more than a political and personal choice by judges to go their own way and follow their political intuitions. Great cases stand both as markers for wayward or lost lawyers and as monuments to the legal community's collective faith in the idea that the common law is, if less than godly, something more than the sum of its members' preferences. In contrast to this jurisprudential staple of traditional thinking, I maintain that the recognition and fate of such great cases is very much about the willingness of the legal community to sustain faith in the importance of the case. A great case is only a great case as long as the lawyers and judges are prepared to treat it as one, or as long as the broader community is not prepared to reject lawyers' animating values. Once the values that underpin a case no longer garner sufficient support or the informing context has changed substantially, a great case will fall by the wayside and be consigned to the ditch of errors, mistakes, and anomalies. For instance, the rise and fall of Lochner's economic due process doctrine had little to do with the quality of its legal reasoning or its doctrinal structure. The case was good law while its values and consequences were considered desirable, and it became bad law when those values and consequences fell out of favor. Accordingly, rather than view great cases as fixed stars or landmarks, I think that it is more appropriate to think of them as temporary lighthouses, designed with a particular purpose in mind. constructed with available materials, and with a limited working life. As society moves, the need for such constructions fades, and other, more useful devices are designed to take their place. For instance, although the House of Lords' decision in Anne's on the two-step process for establishing a duty of care was considered by many to be a potential member of the select elite, its greatness was later denied and its importance rejected in Murphy. As with celebrity, greatness in law is no less dependent on passing trends and shifting contexts. Depending on the audience, today's star is yesterday's wannabe or tomorrow's has been. Moreover, simply because a particular decision has been accepted into the legal canon does not mean that the light it casts is clear or certain. Indeed, as with texts that have received canonical status in literature, the meaning and instruction of such judgments remain indeterminate and undecided. Precedents do not speak for themselves, and their interpretation is an occasion for interested and creative attempts at hermeneutical appropriation. They represent a site for the manufacture of meaning as much as an adequate grounding for a present case's resolution. For some, in law and literature, this richness and opacity are some of the qualities that recommend a text as great. In this sense, both Shakespeare's Hamlet and Lord Atkin's Donegal are great not only because of their profundity, but also because of their profligacy. They lend themselves to diverse and contestable renderings. For instance, in Donegal, the question for the court was whether a ginger beer manufacturer could be liable to someone who became ill after drinking some of its ginger beer, which had been bought for her and which contained a dead snail. It is entirely ridiculous to contend that the House of Lords judgments, or even Lord Atkin's neighbour principle, give rise to any one overriding ratio or ruling. Depending on the context in which the inquiry is made, the leading judgment of Lord Atkin can be convincingly and legitimately analysed to produce a vast array of rulings. What does it tell us about the responsibility of builders, accountants, parents, municipalities, and so on? What does it tell us about liability for omissions or failure to act? What does it tell us about recovery for loss of profits? The answer to each of these answers will emphasize a different facet of the judgment and suggest a slightly different shade of meaning. For instance, even in a most general way, Lord Atkin's judgment can be, and has been, not unreasonably interpreted to support a range of rulings that run from a. Scottish manufacturers in the late 1920s of opaque bottles of ginger beer are expected to check that dead snails are not left in them through m. All persons who make goods or offer services to the public must ensure that they are fit for their intended purpose to z. Everyone should act with due care in their interactions with others. Because the list of great cases is simply a matter of communal consensus, although it is a process in which some opinions carry more weight than others because the legal community is nothing if it is not hierarchical, the listing of great cases is very much an empirical question. As such, this process is largely uncontroversial. A cursory survey of leading textbooks and casebooks evidences a marked consistency in selection and emphasis. For instance, few taught scholars would doubt that Rylands, Donegal, and Hedley Burn were great cases, although many might disagree on their scope and meaning. Similarly, few constitutional scholars would disagree that Brown, Griswold, and Miranda were great cases. Indeed, once scholars do begin to disagree, the basis of a case's greatness is eroded and its celebrated status disturbed. Although some commentators would go so far as to say that an approach to constitutional interpretation is unacceptable if it entails the incorrectness of Brown, it must be remembered that this assessment is only correct as long as the decision is accepted as correct. It is acceptability that sustains correctness, not correctness that determines acceptability. Nevertheless, the recognition of the greatness of these cases does little to explain why such cases have become celebrated as great cases. The definition is more about the consequences of being designated a great case rather than an explanation of why they became great cases in the first place. One possible source of explanation is that such decisions and judgments are fated because of their exemplary stature as embodiments of the common law method through their expert use of legal reasoning and their superlative judicial craft. While such qualities are not irrelevant and are often touted by some jurists as the hallmark of great cases, such an explanation is unconvincing. If the formal qualities of judgments were determinative, there is little reason to believe that we would have the great cases that we have. Some presently included in the canon would be missing and others might be included. For instance, Rylands is hardly an exemplar of legal reasoning. There is little about Lord Kens's judicial craft that makes his judgment stand out as exceptional or excellent. In the same way, Chief Justice Warren's judgment for the Supreme Court in Brown is castigated by many as a very poor model of reasoned elaboration. It bears all the hallmarks of a political compromise intended both to get all members of the Supreme Court to sign on to a unanimous opinion and to cause as little political controversy as possible by limiting the decision and reasoning to school segregation and demographics. Furthermore, There are myriad examples of judgments that live up to the standard of Donoghue's Lord Atkin or O's Justice Blackmun. Indeed, the dissenting judgment of Lord Buckmaster in Donoghue or of Justices White and Rehnquist in Roe cannot be reasonably said to be inferior in terms of craft and professionalism. Consequently, while the stylistic or literary quality of a judgment helps, it is in no way decisive in itself. It is the rhetorical success and political acceptability of the decision that will carry the day. Form and substance. The greatness of great cases is less about their formal attributes than it is about their substantive appeal. Although more removed from the glare of political scrutiny than constitutional decisions, the development of English tort law offers ample support for such a claim. As is so often the situation, what they do is more telling than what they say they do, while what judges say cannot be ignored. Neither can it be taken as the final word. Judicial dicta are the beginning of inquiry, not its end. Decisions such as Donoghue and Hedley-Byrne become defining moments in the shifting and developing doctrinal universe not because they are legally correct or analytically sound in that they follow precedent in predictable or prosaic fashion, but because they are considered politically valid and socially acceptable. Indeed, the very strength and singularity of such cases is that they break with the existing tradition of doctrine and carve out a new path for the law to follow. In this way, the genesis of great cases is to be found in strikingly creative and transformative acts of judicial bravado. The difference between Donoghue and Hedley-Byrne, on the one hand, and other less celebrated cases has almost nothing to do with interpretive cogency or hermeneutical integrity in legal doctrine. It has everything to do with changing currents and concerns in the political context that frame and condition such germinal and disruptive judicial decisions. As Stanley Fish puts it, the canon is a very historical, political and social product, something that is fashioned by men and women in the name of certain interests, partisan concerns, and social and political agenda. If this is true for literature, then it is doubly so for law. For instance, Winterbottom v. Wright, which restricted relief for defective products to contractual remedies, ceased to be a fixed point on the legal compass because it no longer enjoyed sufficient political confidence and support among the legal and political community. The perception that it had an analytically weak, or strong, status was virtually beside the historical point. While the fact that a judgment is crafted in an analytically strong style will facilitate the acceptance of a novel or bold decision, it will not in itself carry the day. Rightness and, therefore, greatness is a matter of social policy and political persuasion, not legal doctrine and logical demonstration. This point is well illustrated by the short career of a great case that never was, Junior Books. The case centered on the much contested question of whether there could be recovery for pure economic loss resulting from a negligent act. In short, following Ann's, it did away with the requirement of related damage to person or property and made the existence of defectively manufactured property sufficient to trigger tortious liability, as well as appearing to put recovery for economic loss on the same footing as other more physical losses. The House of Lords effectively placed tort ahead of contract in the doctrinal hierarchy of civil obligations. Under such a legal regimen, it would no longer be taken for granted that contract was the primary mode of imposing civil obligations or that, without the existence of a contract, people had no legal obligation to safeguard the economic interests of others. In reaching this decision, Lord Fraser maintained that the present case seems to mean to fall well within limits already recognized in principle for this type of claim, and Lord Roskell believed that it represented the next logical step forward in the development of this branch of the law. In contrast, Lord Brandon's dissenting judgment took the view that, in its treatment of Donoghue, the majority had effected a radical departure from long-established authority and created wholly undesirable extensions of the existing law all of delict. Of course, the considerable irony of this is that Donoghue itself was a radical departure from long-established authority, and Hedley-Byrne had been no more a radical departure from Donoghue than Junior Books. Lord Brandon's disagreement had more to do with the wisdom of introducing a transmissible warranty of quality. A plaintiff in tort could be better off than a similar plaintiff with a relevant contract because warranties would run with the product. A subsequent purchaser could have a broader range of legal rights and remedies than the original purchaser. As is now well known, this doctrinal transformation did not take place, and Junior Books did not take its place among the ranks of great cases. The response to Junior Books was decidedly swift and negative. In a series of cases, the courts managed to undermine and cabin the decision without actually overruling it. Abandoning Atkin's search for some golden thread that would make general sense of the law's particulars, the judges opted for a less doctrinaire and more pragmatic approach to tort law. There is no precedent for the application of strict logic in treading the path leading from the general principle established in Donoghue towards the Pandora's box of unbridled damages at the end of the path of foreseeability. Indeed, by the end of the decade, Lord Brandon had managed to persuade all his fellow judges to come over to his way of thinking. In Murphy, it was held that the contested loss was purely economic and was more appropriately dealt with under contract, not tort. Liability based on a transmissible warrant of quality was to be strenuously resisted. The rare septet of law lords in Murphy overruled Ann's, and, therefore, junior books, on the basis that it was not capable of being reconciled with pre-existing principle and, again ironically, that it was too big a jump from Donegal. However, any reasonable reading of the Murphy decision indicates that their rejection of Ann's has more to do with policy concerns about such a doctrinal innovation than a somewhat belated condemnation of Ann's failing as a matter of legal analysis. The law lords were not prepared to allow tort to eclipse contract as the primary mode of civil obligation. Accordingly, junior books' fate offers substantial confirmation that a case's status as a great case has more to do with its substantive desirability than its legal unsoundness. If legal soundness, that is, whether a decision was a reconcilable extension or modification of existing principle, is the test, Donegal itself, the epitome of a great case, would be rendered suspect. Of course, to talk of legal soundness as though it were something entirely different from substantive desirability is an artifice. There are few judges, let alone jurists, who would be prepared to make such a formalistic pronouncement. While substantive desirability can act as a component of legal soundness, it cannot be reduced to it. The judicial effort to defend their work in terms of principled decision-making is made for an eminently good and, at least in traditional terms, compelling reason. Judges are acutely aware that their primary role is supposed to be to develop and apply the law from existing principles, not to legislate with little regard to the past. A candid confession that great cases are less of a principled continuation of existing doctrine and more a radical departure from it puts the jurisprudential defense of the common law into serious jeopardy. For instance, in Headley Bairn, Lord Reed was adamant that Donegal may encourage us to develop existing lines of authority, but it cannot entitle us to disregard them, and Lord Devlin emphasized that, as always in English law, the first step in such an inquiry is to see how far the authorities have gone, for new categories in the law do not spring into existence overnight. Nonetheless, while this effort is understandable, its convincing performance is fraught with difficulty. Indeed, attempts to explain the jurisprudential basis of great cases are caught between a rock and hard place. On the one hand, if great cases are seen to be a continuation of existing doctrine, it is a tradition that is so ample and generous that it can embrace almost any judicial act. The reality will be that anything might go and that the limits of common law adjudication are nothing more, and nothing less, than the political limits of the judges. Judgments will stand or fall on the judges' rhetorical ability to persuade their colleagues of their political merit. Such a situation seems anathema to traditional opinion. On the other hand, if great cases are seen to be a break with existing doctrine, then their very legitimacy is questionable. Although law emphasizes the routine, it will be the revolutionary occasions of great cases that best capture its dynamic spirit. Either way, the judicial accounts of the common law's development as incremental and piecemeal concede too much, that is, almost any case is seen to be a routine continuation of common law tradition, or too little, that is, all great cases are seen to amount to a revolutionary change in the common law tradition, for their own jurisprudential good. This dilemma can be easily and instructively demonstrated by reference to the competing judgments in Donegal itself. Lords Buckmaster and Tomlin took the view that not only were the existing authorities against Mrs. Donegal, but also that the common law did not evince any principles that would support her claim. Although, the common law's principles are capable of application to meet new conditions not contemplated when the law was laid down, yet themselves cannot be changed nor can additions be made to them because any particular meritorious case seems outside their ambit. Of course, the minority did not rest their disagreement on legal analysis alone. They went on to take fundamental exception with the substantive wisdom of the majority's decision. In response, the majority pointed to the inconclusive state of the authorities and claimed that, although the neighbor principle was not the only possible interpretation of the existing precedents, it was the best substantive outcome. However, both Lords Atkin and Macmillan were prepared to state that the law must keep pace with prevailing views of justice. Indeed, Lord Macmillan went so far as to approve of the view that any proposition the result of which would be to show that the common law of England is wholly unreasonable and unjust cannot be part of the common law of England. In short, while the effort to follow principle is to be preferred, such a formal responsibility will not stand in the way of substantive fairness. When push comes to shove, judges should favor justice over precedent. In this classic exchange between Donegal's minority and majority, the extent of the jurisprudential dilemma with which great cases confront the common law is revealed. In gallantly attempting to cover all the jurisprudential bases, the majority in Donegal only managed to expose the fragile and, I will argue, illusory foundations of the common law. While Lords Atkin and Macmillan can be applauded for their candor and their willingness to put substantive justice ahead of formal argument, they highlight the fact that the common law is not best understood as a limited, predictable, and peculiarly legal mode of decision-making, but as an open, unpredictable, and distinctly political process in which anything might go. Under even a minimalist traditional account of the common law, there is some obligation to maintain some critical distance between the two. Once substantive desirability is made the sole test of legal soundness, the common lawyer seems to have offered less an account of common law decision-making than an account of decision-making per se. However, if substantive desirability is the only test, then any pretense that the common law is about a formal adherence to existing rules and established principles is seen as a hollow and occasionally hypocritical stance. The common law is through and through a political project in which substance eclipses form. This is amply demonstrated by the role of great cases in constitutional law. Although there are obvious differences between the adjudicative performance in ordinary common law cases and constitutional cases, constitutional adjudication is simply a particular kind of common law adjudication. The basic components of the common law mindset are adapted to the specialized demands of the constitutional context. Constitutional challenges. In exercising their power of constitutional review, courts are as much or as little bound by the supposed doctrinal authority of great cases as they are by the controlling precedents of the common law. Thus, it is the canonical force of great cases as much as the explicit wording of the Constitution that is at the heart of constitutional adjudication. The balance between the two is contingent and contextual. Indeed, even a relatively passing familiarity with the history of American constitutional law confirms that judicial discourse is as much about squaring present decisions with past cases, albeit as privileged efforts to interpret the constitutional text, as it is about conformity to the actual words of the governing document. If anything, the American constitutional tradition offers a rich and potent demonstration that, while there is and likely will always be a canon of great cases that holds considerable doctrinal sway over the judicial and scholarly intellect, the number and identity of those cases as well as their meaning will change over time. Canonicity is about substantive effects, not formal attributes, and what gets treated as canonical will be a matter of continuing substantive acceptance rather than fixed formal recognition. The effort to rely on a fixed canonical tradition of constitutional great cases is as weak and unsuccessful as the judicial effort to utilize social tradition to ground constitutional interpretation. Both traditions are so numerous, imprecise, and open that they can justify almost any reading. Indeed, this resort to tradition tends to more reinforce than resolve the problem because it is difficult to ascertain what would be the controlling tradition, constitutional or social, over and above a particular judge's honest conviction about what was. Brown is one of a handful of cases that almost everyone agrees has a special place in the American constitutional tradition. However, beyond that general fact, there is little agreement. Its judgment, the doctrinal basis of the decision, and its academic reception are all extremely problematic and hotly contested. The judgment in Brown represents a site for the manufacture of meaning as much as an adequate grounding for its actual resolution. In a rhetorically bland but politically explosive judgment, a unanimous Supreme Court held that the inconclusive nature of the 1868 14th Amendment's history obliged it to take notice of the contemporary state of public education and strike down Plessy's separate but equal doctrine. In reaching this decision, the court delivered a judgment that was short on doctrinal argument and long on practical imperatives. Rather than cite text or precedent, the judges chose to rely on social statistics. Indeed, although the court's brief judgment tried to sidestep the larger and more troubling questions of constitutional legitimacy, it only managed to emphasize their importance and the extent to which the Brown judgment itself was wanting as an exercise in constitutional adjudication. While couched in more conventional terms, academic commentators engaged in an almost unparalleled project of result-oriented rationalization. The rejoicing in the substantive result was only matched by the lamentation at its inadequate reasoning. Indeed, the Brown decision points up the classic tension in constitutional adjudication. In general terms, it pits the originalists against the non-originalists in the challenge to avoid reducing adjudication to the mere reflex of the popular opinion or passion of the day, if there is a move beyond framers' intent, even on the limited basis that it is impossible to isolate it in sufficient specificity. What is the source that judges can and ought to use to inform and limit their decisions? However, although the non-originalists face the more obvious and stiffer challenge of maintaining a distinction between law and politics, the originalists are no less implicated. The availability, applicability, and acceptability of original meaning are far from technical or non-political inquiries. Brown, therefore, points up the central dilemma in constitutional law, to demonstrate convincingly that Brown is not only politically appealing and that Plessy is politically deplorable, but that Brown is good constitutional law and Plessy is bad constitutional law. This is a more concrete way of expressing the more general challenge for common lawyers of refuting the critical claim that law is politics. While there is an obvious and necessary link between law and politics, even the most sophisticated of constitutional commentators and common law theorists insist that there is a definite and discernible difference between law as a public institution and political morality as a personal commitment. Telling it how it is means, up to a point, telling it how it should be. Accordingly, constitutional judges and jurists must be able to explain why something is good constitutional law in terms other than simply because it is good politics. Once the difference between good law and good politics is no longer maintained, there is no reason to treat legal decisions as any more neutral, objective, or non-ideological and, therefore, authoritative than political opinion. Efforts to delineate and sustain this distinction are ingenious and elaborate, but they either prove too little for their own political good or too much for their own legal good in responding to the various crises of human affair. The law fails to live up to political expectations, or political expectations call the legal tune. Although the task of reconciling constitutional law and partisan politics is difficult in a single case such as Brown, it becomes positively Sisyphean when one throws in all the other contested great or almost great cases. How is it possible to demonstrate conclusively that some permutation of Brown, Roe, and Lawrence is or is not good constitutional law in a way that is somehow different from the general debate over what is and is not good politics? The answer is that it is not possible and that great cases are less landmarks to doctrinal integrity than monuments to its indeterminacy. The fact that the Constitution develops and changes is not so much the problem as the how, when, and whether constitutions develop and change. These crucial questions have to be answered largely by reference to the dynamics of constitutional law as a relatively separate and independent process from the volatility of changing political circumstances. Constitutional law and politics cannot be one and the same thing, as there is no one politics and therefore no one constitution. The maintenance of such a law-politics distinction might be plausible in a society that shares a general consensus on politics. But, of course, that is not the case in American society, especially for, or perhaps because of, the constitutional cases that fall for judicial decision. The contested status of Roe is another example of the freighted dynamics of constitutional adjudication and the importance of substantive political values over formal legal arguments. Few cases have elicited such impassioned responses. This is not surprising in light of the divided social views on abortion. However, notwithstanding the best efforts of academic and professional opinion to present the debate differently, this is exactly what both sustains the legal antagonism and prevents the establishment of any settled constitutional stance. Although the contesting factions frame their arguments in the familiar vocabulary of legal legitimacy as much as political desirability, there is nothing to choose between them in terms of doctrinal correctness. While judges and jurists argue over whether the decision is routine, that is, the incremental development of the privacy logic of Griswold and related cases, or evolutionary, that is, the overstepping of accepted doctrinal boundaries of those cases, these are really nothing more than coded strategies for highly charged political initiatives. Indeed, Roe and the committed efforts to retain or reduce its meaning represent as keenly as any other modern-day encounter the struggle over the soul of constitutional law. Roe will remain a valid and authoritative decision as long as its assailants are unable to persuade others of its substantive injustice and of the political wisdom of eroding still further the fragile legitimacy on which the Supreme Court so heavily relies for its continuing moral legitimacy when it is seen to act in such a transparently political way. The fate of Roe as a great or not so great case will, like all other cases, be determined by the contingent outcomes of political engagement. As politics goes, so goes the Constitution. Of course, Brown was not entirely out of the blue. The Supreme Court had begun to chip away at the Plessy doctrine over the previous couple of decades. However, as both the popular upheaval and professional fallout evince, the decision was far from a routine extension of existing precedent or a natural progression from established doctrine. Indeed, the brevity of the judgment, its unanimity, and its sparse argumentative basis all speak to the lengths that individual members of the court were willing to go to present a consolidated front in the face of the controversial substance of the judgment, its likely implications, and the expected onslaught on the court. Again, as I argued in regard to English tort law, if Brown is defended as a continuation of existing tradition, then the available resources of legal precedents are so capacious as to warrant almost any particular result or development. If that is the case, the level of generality and the placing of emphasis can be manipulated legitimately to favor or foreclose almost any line of doctrinal development. However, if Brown is treated as a deviation from existing traditions of constitutional doctrine, then the supposed discipline and regimen of constitutional adjudication is undermined. Transformation and change seem to be the traditional order of the constitutional day. Moreover, the thin doctrinal basis on which Brown was laid and the convoluted efforts of jurists to offer a more compelling legal rationale further support the critical claim that Brown's general acceptance as a great case has much less to do with internal, doctrinal, and formal considerations and more to do with external, political, and substantive concerns. Although Brown's tenure as a great case was up in the air for some time, it was not legal argument or academic rationalization that pushed it over the top. It is surely more convincing to concede that the genesis of Brown is to be found in both a strikingly creative and a relatively constrained performance of the judicial craft that breaks with existing legal traditions at the same time that it transforms those traditions. Great cases, like Brown, do not so much give the lie to the critical claim that law is politics, but provide the best evidence of its cogency and force. Law is thoroughly permeated with politics, and any attempt to distinguish one from the other is destined to be so trivial as to be of no theoretical significance or so convoluted as to be of no practical import. Decisions like Brown become great cases in the shifting constitutional universe not because they are legally correct or analytically sound, but because they are considered politically valid and socially acceptable. They remain in that exalted position only as long as their political base and social legitimacy can be sustained. The difference between Plessy and Brown has nothing to do with their interpretive cogency or hermeneutical integrity as a matter of constitutional doctrine. Indeed, there is little in Brown that makes it formally or stylistically superior as a legal decision to Plessy. It has everything to do with the changing currents and concerns in the shifting political context that frame and condition such germinal and disruptive judicial decisions. Plessy ceased to be a fixed point on the constitutional compass because it no longer enjoyed sufficient political confidence and public support. Its perception as having an analytically weak or doctrinally suspect status was beside the historical or legal point. Its constitutional rightness was a matter of social policy and political persuasion, not legal authority or doctrinal cogency. When Justice Harlan predicted that the Plessy judgment will, in time, prove to be quite as pernicious as the decision in Dred Scott, he was talking about its substantive merits as a political event, not its formal qualities as a legal judgment. Indeed, as the harrowed academic response to Brown again demonstrates, it was, and still would be, difficult for traditional common lawyers to recognize Brown as a sound or correct legal decision in the summer of 1954, without abandoning their cherished commitments to even a minimalist doctrine of stare decisis. Adding the fact that Brown is a constitutional decision only serves to compound the severity of the challenge. Consequently, although Brown is still revered as a great case whose intimations must be incorporated into any valid account of constitutional law, it actually throws judges and jurists on the painful horns of the perennial dilemma: either it is bad constitutional law, in which case it confirms the fear that constitution law is basically a reactionary practice, or it is good constitutional law, in which case constitution law is capable of sustaining all kind of diverse and often contradictory interpretations. In short, accept Brown and you accept almost all interpretations, reject it and constitutional law is very problematic as a just source of democratic governance. The relative fates of Brown and Lochner are very much on point. The Supreme Court's 1905 decision in Lochner has been pilloried and held up as an anti-great case. Its canonical authority is found in its standing as exactly what the Constitution does not stand for and exactly what judges should not do if they want to act legitimately and appropriately. However, its genesis and trajectory are not dissimilar to Brown. Whether viewed as an extension of existing precedent or as a break from it, Lochner's precise ambit left much open to interpretation. It neither followed inexorably from previous decisions nor represented an aberrational moment in constitutional discourse. Its doctrinal legitimacy was no more and no less assured than most other leading judgments. Moreover, while its quality in terms of judicial craft is far from outstanding, it is clearly the match of Brown's cursory product. Nevertheless, Brown was and is the case that has been acclaimed and treated as great. This can only be understood as a matter of substantive politics. In the same way that a literary work's greatness and authority is a function of historicized rather than universal standards of judgment, so the status of great cases is less a matter of formal accuracy than substantive appeal. Legal and literary texts are championed by people because their qualities speak to them in a powerful and stimulating ways, and they will remain of canonical stature for as long as people think that. However, their continuing preeminence is as much about what people think as it is about something intrinsic or transcendent in the texts themselves. Canonicity is what is bestowed on texts, not something that a text simply has. Great cases do have an authority and therefore a conversation-stopping quality in legal debate, But this is not because of some inherent or enduring force that they autonomously possess. Great cases have to earn their authority in the political squares of legal and popular opinion. Once that opinion begins to shift, the canonical force of such cases will be affected accordingly. Talk of error or mistake is a rhetorical device to justify a particular substantive position or a change in the law. Great cases are only as authoritative as the political values that they represent and by whose forbearance they are held in place. It is not so much that Brown got it right and Lochner got it wrong as a matter of textual exegesis or doctrinal development, but that the substantive values that Brown represents seem to remain more conducive to popular opinion than Lochner's. However, I say seem because, although Brown is still loudly and regularly feted and Lochner is castigated with equal force, the reality may be different. On the one hand, Brown's influence and, therefore, canonicity is waning as conservative forces reassert themselves. The metaphorical emphasis in equality doctrine on a color-blind constitution threatens to subvert the progressive tilt of a more situated and historically sensitive discrimination doctrine. On the other hand, Lochner's influence is actually waxing as the ideological appeal of a substantive standard for protecting economic rights against state regulation becomes more attractive. The trend is to reject Lochner by name and reference but to resurrect it in style and substance. These turn of events say much about the common law and the status of great cases in its development. As disturbing as they might be to some, and encouraging as they might be to others, they do little to sustain the idea that law and adjudication are driven by the law's intellectual discipline. On the contrary, politics is the motor force of the common law, and it is judges' attachment to particular and partisan substantive values that steers it in one direction or another. When Borkin and Levinson ask whether cases like Miranda and Brown are sacred cows that cannot be touched or whether they are revisable like everything else, the question is misconceived. Such cases are both sacred cows and reversible like anything else. As long as they are accepted as being part of the constitutional canon, they will have the authority and force that any canonical case has, which, of course, will be far from fixed or certain. However, because the contents of the canon are revisable, such cases are as reversible as any other. In a manner of speaking, constitutional law's sacred cows are only bovine and not divine. They serve someone's distinctly human purposes rather than validate those purposes as universal or enduring. There is no legal theory that will or can guarantee that Brown and Roe will remain or that Plessy and Lochner will never resurrect themselves. There are no doctrinal or jurisprudential formulas that can underwrite any particular course of constitutional development in dealing with the various crises of human affair. Nor will judges who go in one direction rather than another be able to claim that they are acting in a more constitutionally legitimate manner. This does not mean that there are no grounds for constitutional law in the sense of arguments or reasons, it simply means that there are none that are final or determinative by sheer weight of their normative force. As great cases show, judges can do much what they like, provided that they can persuade enough of their colleagues to support their view and that the ensuing decision will garner sufficient popular tolerance. Good constitutional law is whatever is accepted as good constitutional law, there is nothing else to it. Great cases are the proof of that critical claim, not its refutation. Back to the Future. The occurrence and importance of great cases obviously has a marked effect on any claims about the nature and operation of the doctrine of stare decisis. While the circumstances of the birth of great cases challenge its whole conservative thrust, the tenacity and influence of great cases reinforces the centrality of precedential authority to the common law. Indeed, modern courts have begun to recognize that state of affairs. Instead of pretending that the common law's development is a seamless web of continuing substantive commitments, judges have sought to revise the doctrine of stare decisis so that it is better able to accommodate explicitly the apparently contradictory impulses to which great cases give rise. There must be some growth and flexibility in the common law, but there must also be some continuity and certainty. Contemporary judges frequently acknowledge that precedent has never been the refined practice that theory recommends. Indeed, the idea that the common law is or was a coherent body of organized rules that was applied consistently and conclusively is belied by the historical record. Nevertheless, this does not mean that stare decisis has no relevance or rigor. Judges have sought to develop a compromise position between an understanding that earlier decisions constitute an instructive baseline and have informational status and an understanding that such decisions are dispositive of present dispute. They have insisted that following precedent is not an all-or-nothing choice between blind adherence and total disregard. Some courts have been considered to have gone so far as to announce that stare decisis is neither a doctrine nor a strict rule of law, but rather is a sub-doctrine of ostensibly wise judicial practice, procedure, and policy. While I agree with such a stance, I do not think that it can be achieved or maintained as a matter of legal principle in some way distinct from substantive politics. On the contrary, I believe that such an effort at compromise by the judicial community is a concession and confirmation that law is thoroughly political and that anything might go. As great cases confirm, both the cause and engine of the common law's development, as well as the constraints upon it, are substantive political commitments. In utilizing the past to guide the future through stare decisis, the courts have paid special attention to the question of when is it appropriate to overrule an earlier decision, or, to put it more informatively, when a court can hold that an earlier judgment that establishes a particular rule or principle has not only been erroneously decided but that it should be discarded and replaced by a different rule. It is trite learning, of course, that the mere fact that a later court considers an earlier decision to be wrongly decided is not enough in itself to warrant its abandonment or overruling. To maintain otherwise would be to rob stare decisis of any bite at all. It is ostensibly a formal doctrine that demands precedents be followed simply because of their historical pedigree, not only because of their substantive appeal. In short, overruling should only be permitted when there is some special or super justification over and above the claim that the earlier decision is wrong. Although courts are understandably reluctant to break from a long-standing legal tradition or ruling, they are not only prepared to do so but place an obligation on themselves to do so at times. For instance, in Planned Parenthood v. Casey, the Supreme Court divided over whether Roe should be overruled. Speaking jointly for the court, the plurality of Justices Souter, O'Connor, and Kennedy stated that there are moments when the court best fulfills its constitutional duty by repudiating earlier lines of cases. In constitutional adjudication, as elsewhere in life, changed circumstances may impose new obligations, and the thoughtful part of the nation could accept each decision to overrule a prior case as a response to the court's constitutional duty. According to the plurality, this should occur when the court would have to pay a terrible price for a failure to act, as was the case in both West Coast Hotel and Brown. However, cautioning that each generation must learn anew that the Constitution's written terms embody ideas and aspirations that must survive more ages than one. The judges maintained that Roe not only did not warrant overruling but that its repudiation would seriously weaken the court's capacity to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. However, the plurality was careful to emphasize that its affirmation of Roe was based on a consideration of the fundamental constitutional questions resolved by Roe, principles of institutional integrity rather than exclusively on the rule of stare decisis alone. Documents and doctrines combined. In short, a plurality of the Supreme Court decided that, if the stakes are high enough, the fallout sufficiently severe, and the judges are so disposed, the breaking with established constitutional tradition will occur. This is exactly what the plurality endorsed. It was not that Justices Souter, O'Connor, and Kennedy thought that such a course of action was entirely illegitimate in the sense that the court had no business overruling its own precedents. It was simply that Casey was not thought to be an appropriate occasion or time to act. It was an ideological call, not a legal one, about social circumstances and political climate. The plurality's judgment is not replete with extended parsing of established cases and principles, but is squarely framed in terms of a series of pragmatic and prudential considerations. Substantive fairness trumps legal soundness. In pursuing the Casey approach to stare decisis, while I do not want to go far as to suggest that stare decisis is a hoax designed to provide cover for a particular outcome, not a genuine, principled ground of decision, I do maintain that the doctrine of precedent does not prevent inventive judges from doing whatever they wish. They can still, as evidenced by Chief Justice Warren in Brown and Justice Blackmun in Roe, achieve the substantive result that they wish and claim to be following precedent. Moreover, for the same reason, the invocation of stare decisis as a reason for not changing the law is no more convincing or principled. Judges opt for inertia for political reasons as much as legal ones. There is no sharp distinction between a cover for a particular outcome and genuine, principled ground of decision. The only significant difference between principled and non-principled decision-making, as distinct from corrupt or bad faith decision-making, is that, in the former, the general principles used and their particularized application win enough overall support to warrant their continued acceptance. Behind the rhetorical cover of principled argument is the genuine dispute over particular substantive political commitments. When the Supreme Court's catalogue of overruling criteria is taken seriously, there is no neutral or non-controversial way to determine what a series of pragmatic and prudential considerations demand, when changed circumstances are sufficient to warrant legal innovation, and how to ascertain when there are new obligations. These criteria are not so much solutions to a problem as restatements of the problems to be resolved. Making law dependent on assessments of social change is the quintessence of a political undertaking. In deciding any case according to the common law method, judges must perform two separate maneuvers. they must interpret what an earlier decision means and then determine what the doctrine of stare decisis requires to be done with that interpretation. These are sufficiently indeterminate and highly contested activities when understood independently, but, when they are joined together, as they must be, they become even less amenable to any precise and determinate instruction. In short, the different possible ways in which judges can legitimately perform their common law responsibilities are so many that they have an almost limitless range of choice. Judges know how to mouth the correct legal rules with ironic solemnity while avoiding those rules' logical consequences. And, of course, the generation and pedigree of great cases is the best evidence of this. In short, there is no strictly legal method by which an earlier decision can be determined to be wrong, let alone that there is some other special justification for its overruling, that can be distinguished from a more open-ended ideological inquiry. Consequently, common law judges are always caught in a bind in which they must balance off competing considerations with neither weights nor scales to help them. It is an inevitable and inescapable political exercise. Of course, any decision reached or judgment delivered can be criticized in terms of craft or political orientation, but it cannot be condemned as invalid or illegitimate simply because it was made with reference to particular and controversial political values. A decision is only wrong insofar as its antagonists would have reached another decision or constructed a different judgment. The continuing debate around Brown is the fabled example of this. Consequently, I do not so much deny the existence and force of stare decisis, as insist that the fact that judges tend to reach similar conclusions speaks more to their shared values than any disciplining legal protocol. Authority, casual or continuing, is something that judgments earn rather than possess. Any perceived legitimacy crisis in adjudication has less to do with the contemporary practice of adjudication itself than the greater diversity of society and its contested values. Judges do much the same as they have always done, only now that there is an increasing diversity in judicial ranks and a decreasing willingness on the public's part to accept judicial decisions at face value, the political quality of the judicial performance is less concealed. In acting legally, judges are also and always acting politically. Great cases are the most compelling evidence of this. The failure of judges to provide a cogent defense of stare decisis operation is matched by their juristic counterparts. Their analysis may be more sophisticated and sustained, but the result is the same. Although there is much disagreement among traditional scholars, there remains an important and unifying commitment to demonstrating that not only can the common law balance the competing demands of stability and change, but also that it can do so in a legitimate way that respects the important distinction between law and politics. It is clearly my view that such a commitment cannot be sustained and that, if the common law is a tradition, it is as much one of change and innovation as it is of stability and continuity. Great cases are an excellent pointer to the character and performance of the common law. They fit only partially, if at all, into traditional evolutionary accounts of the common law. Indeed, great cases are more of a refutation of the incremental hypothesis, not a demonstration of its validity. Rowlands, Donegal, and the like can hardly or reasonably be described as incremental adjustments to the common law body of rules and principles, let alone as affirmations of existing traditions. Again, judges and jurists are left with a stark choice. They can either recognize great cases as revolutionary moments in the common law's development and revise their accounts of the common law to accommodate them, with all the subversive consequences that entails, or they can deny that great cases are revolutionary moments and acknowledge that incremental change encompasses any and every change to the common law, with all its equally subversive consequences. In either case, the result will be both a realization, no matter how begrudging, that, when it comes to the common law, anything might go, and an abandonment, no matter how reluctantly, of the jurisprudential insistence that law and politics are separate. Of course, contemporary jurists have sought to resist this result with all the theoretical means at their disposal. However, what begins its jurisprudential life as a reassuring promise of justifying incremental development runs the risk of quickly and easily turning into a subversive threat of permitting wholesale transformation. In searching for the fragile developmental equilibrium between stability and change, common law apologists tread a precariously thin line between a legitimate practice of unfolding reform and an illegitimate exercise in episodic revolution. This is a tall order for any legal theory, and one that the demand to explain the emergence and existence of great cases turns into an almost impossible one. If great cases are the crowning glory of the common law tradition, they are equally the Achilles heel of its jurisprudential apologists. Indeed, Posner has announced that judges and jurists should no longer be interested in such an endeavor, even in constitutional matters. He maintains that their time would be better spent if they abandoned such theoretical indulgences and devoted their energies to examining the social contexts of constitutional issues, their causes, their costs, and their consequences. However, as I have sought to demonstrate, Posner's approach is more a strategic ploy than a genuine position. Although he unceremoniously throws moral and political theory out the front door of jurisprudence's mansion, he lets in its economic siblings sneakily through the back door. Thus, the bulldog breed of jurist has not so much resolved the common law's dilemma of explaining great cases as ignored it. To his credit, it is again Dawkins who has sought to offer a comprehensive account that will encompass and explain the existence and force of great cases. However, his failure to succeed in this task is ominous for almost all traditional jurists who rely on a principled account of the common law's development as well as individual adjudicative performances. Dawkins advances an understanding of adjudication as a political practice that works the space between law's institutional past and its future possibilities. To him, any interpretation of the legal materials must be able to demonstrate some plausible connection to society's legal history and, in that important sense, be continuous with that past. While the better interpretation is not necessarily the one that accounts for the most decisions, the settled body of legal norms and justifications is claimed to be the motor force of principled adjudication. Law's attitude aims, in the interpretive spirit, to lay principle over practice to show the best route to a better future, keeping the right faith with the past. In short, Dawkins' interpretive ideal of judicial integrity seeks to combine both backward-looking and forward-looking elements by insisting that judges view what they do as an unfolding political narrative that begins in the present and pursues the past only so far as and in the way that present practice can be organized by and justified in principles sufficiently attractive to provide an honorable future. Along with the idea of legal continuity, Dawkins maintains that the judges should treat the law as if it were a seamless web, providing complete and determinate guidance on all legal disputes. There is no need or justification to leave the law behind and engage in unconstrained choice. Accordingly, Hercules is most certainly no revolutionary figure and is trusted to uphold the wisdom of the past, albeit in imaginative and innovative ways. Convictions about fit will provide a rough threshold requirement that an interpretation of some part of the law must meet if it is to be eligible at all. That threshold will eliminate interpretations that some judges would otherwise prefer, so the brute facts of legal history will in this way limit the role any judge's personal convictions of justice can play in his decisions. Different judges will set this threshold differently, but anyone who accepts law as integrity must accept that the actual political history of his community will sometimes check his other political convictions in his overall interpretive judgment. If he does not, he is acting from bad faith or self-deception. Despite the ingenuity of his theory and its robust defense, Dawkins' efforts create more and larger problems for his general account of common law adjudication than they resolve. Dawkins wants it both ways. He wants to demonstrate that the common law is both open and closed. It is open in that the judges are able to develop the law in new and unexpected ways and, at the same time, it is closed in that judges cannot ignore the brute facts of legal history in favor of their own political convictions. The fact is that, within the traditional jurisprudential project, the price of having one is the cost of having the other, particularly so in regard to great cases. If his claims about fidelity to the legal past mean that any constructive account of the law must accommodate great cases, then his theory is on the mark as an account of adjudication as a partially closed as opposed to an entirely open practice. However, when such a constraining requirement is taken seriously, the birth and acknowledgement of future great cases, those that represent a radical departure from extant principles, not their incremental development, seems well nigh impossible. On such an account, great cases negate rather than exemplify the quintessential character of valid adjudication. The common law is a complex of principles that justifies radically different and contradictory readings. As Dawkins himself concedes, how the dimensions of backward-pulling fit and forward-pushing substance relate to each other is in the last analysis all responsive to judges' political judgment. While this is an acceptable conclusion for someone, like me, who maintains that the common law is a work in progress and that anything might go, it is a curious and ultimately disappointing confession for any theorist devoted to refuting the critical claim that law is politics. Nevertheless, aware that his emphasis on fidelity with the past might back him into some politically unattractive corners, Dawkins tries to provide Hercules and lesser judicial mortals with a convenient escape route. Consequently, he argues that, in exceptional and unusual circumstances such as those in Nazi Germany and apartheid South Africa, judges are entitled to forego compliance with even the minimal demands of formal fit, if a judge's own sense of justice condemned the grounds of law as deeply immoral. He would have to consider whether he should actually enforce it, or whether he should lie and say that this was not the law after all, or whether he should resign. While this might seem to extricate Hercules from some tight spots, it actually has him jumping between the frying pan and the fire. On the one hand, If such a radical maneuver is only justified in grotesque societies such as Nazi Germany or apartheid South Africa, it is difficult to envision how great cases meet that standard. Although Donegal might have dealt with instances of consumer injustice that were by no means insignificant, it is a considerable stretch to place such injustice on the same level as what went on in those blighted societies. That being the case, Dawkins' deeply immoral exception will have problems incorporating and accounting for great cases. On the other hand, if the meaning of deeply immoral is to be determined by a judge's own sense of justice, then the opportunities to finesse the minimal backward connecting demands of formal fit will be as broad or as narrow as the range of judges' political commitments. Accordingly, provided that judges do so on the basis of sincerely held beliefs, they are free to lie, resign, or refuse to enforce the law. In short, judges need only keep faith with the past insofar as it accords with their own sense of justice. Or, as Lord Pearce put it rather more subtly, but no less revealingly, in Hedley Bairn, how wide the sphere of the duty of care in negligence is to be laid depends ultimately upon the court's assessment of the demands of society for protection from the carelessness of others. Indeed, the history of the common law is redolent with judicial pronouncements that the touchstone of good judging is the strength and sincerity of judges' political beliefs, not the moral force of the extant law or particular judge's fidelity to it. As Lord Macmillan concluded in Donegal, any proposition the result of which would be to show that the common law of England is wholly unreasonable and unjust cannot be part of the common law of England. This is a powerful and appealing notion, but it undermines, not confirms, the Dawkinesque appeal to principled integrity as the heartbeat of the common law. Routines and riders. Throughout this chapter, I have made a series of critical claims that will likely ruffle the feathers of most, if not all, legal theorists. This, of course, is to be expected because the account of the common law that I have offered is intended to challenge existing ideas and to undermine traditional understandings. Rather than treat great cases as anomalous occurrences that require special explanations, I place the incidence, importance, and influence of great cases at the heart of the jurisprudential project. In this way, it becomes possible to appreciate that the price of the common law's ability to change and adapt is the cost of it being understood as a fundamentally political undertaking. If there is any unifying thread to the smorgasbord of modern jurisprudence, it is the theoretical conviction that law and politics are not one and the same, such that what judges believe to be good politics is also good law. I insist that such a fundamental distinction cannot be maintained. However, there is one likely response to my arguments that can be readily identified and warrants immediate rebuttal. Although it comes in various shapes and sizes, the basic riposte to the critical claim that law is politics is that, while this might be a credible claim in some celebrated instances, the greater part of judicial activity is ordinarily formalized and politically detached. Specifically in regard to great cases, it is argued that, by their nature and status, they are more the exception than the rule and, as the proverbial wisdom has it, prove the rule. The common law is by and large a disciplined process that is exemplified by the routine and uncreative application of existing law. It is contended that to understand the common law only by reference to so-called great cases is to allow the political tail to wag the legal dog. Fortunately, time and attention have not been kind to this routine line of traditional argument. When it is understood properly, this familiar distinction between so-called routine and revolutionary cases adds fuel to the critical fire rather than extinguishes it. While the claim is true insofar as much adjudication is mundane and prosaic, such a characterization cannot carry the jurisprudential day. To my way of thinking, all decisions are political in that even allegedly rigid differences to tradition are more realistically characterized as normative approvals of the specific outcome suggested or of the tradition generally because it jibes with the present critical commitments of the judge. There is never a situation in which judges do not have the opportunity or responsibility to be creative. Whether they choose to utilize that chance is a different matter. Once it is conceded, as it must be, that great cases are a valid feature and product of the common law process, the quotidian operation of the adjudicative function has to be viewed in a more expansive way. When judges appear to be following precedent and to be framing their judgments in terms of legal authority, it is more that they are approving of the substantive desirability of the outcome that arises from a reasonably traditional reliance on existing case law. In other words, it is the end result and not the reasoning means that is controlling. The spectre of great cases, the possibility that judges cannot only reject traditional approaches, set off in new directions, and still be acting in an appropriately legitimate manner, but also be celebrated for so doing, suggests that, because there is always the strong discretion to do something else, judges must actually make a positive choice to opt for a precedent-directed decision, as it is the particular substantive values in play rather than the formal general logic of the law that govern. The judges in routine instances are choosing not to be radical or transformative. In any system that allows and provides for change, the decision to remain with the status quo cannot be politically neutral or apolitical. It really is as much a political decision to stand bait as it is to change. Indeed, when viewed in the critical light that I recommend, the jurisprudential problem becomes less about whether there are too many great cases but whether there are too few of them. As the late Roger Traynor Riley commented, the real concern is not the remote possibility of too many creative opinions, but their continuing scarcity. For instance, a powerful constraint on judges is their felt need to protect the democratic legitimacy and integrity of the courts as they are thrust into highly charged areas of public policy. There is a clear sense in judicial quarters that, unless it can be reasonably demonstrated that there is some certainty and predictability to law, public confidence in the rule of law and, therefore, the courts would be seriously jeopardized. The doctrine of stare decisis permits society to presume that bedrock principles are founded in the law rather than in the proclivities of individuals. Efforts to diffuse this charge often manifest themselves in a heightened attachment to the doctrine of stare decisis or, at least, a rhetorical insistence on its constricting influence. However, this maneuver is less a turn away from politics and more a shifting of political ground. Stare decisis might be presented as a technical device, but it is a settled and indeterminate policy in that stability and continuity are value considerations that judges must weigh and be weighed in their decision-making process. However, the way in which those values are calibrated must be done by reference to some other set of political convictions. It is the substantive justice of the result and the public reputation of the judicial process generally that has priority over the formal virtues of precedent adherence. It is surely the case that public confidence in the courts would be more seriously damaged if the court stuck to an established precedent when there was overwhelming support for a different substantive outcome. As the careers of both Brown and Rowe indicate, the connection between public support and judicial resolve is difficult to plot and is itself subject to varying political considerations. Although such traditional values are often passed off as peculiarly legal, formal, and neutral, they are as political, substantive, and contested as they come. By giving priority to institutional stability over individualized justice or wholesale reform, the courts are engaging in a very fundamental political exercise. Conservatism is no less ideological than progressivism. Moreover, a commitment to stare decisis is really no constraint at all. Accordingly, the fact that great cases are few and far between does not support the claim that the judicial development of the common law is a politically neutral or internally driven. Although it seems entirely reasonable and unexceptional for the common law to defend an approach in which what has happened previously will affect what will happen later, it is a huge step to advance the further claim that what has happened previously must necessarily constrain or bring about what will happen next. When judges decide to follow existing doctrine rather than overturn it, they are not refraining from political assessment, they are choosing to make such evaluations in terms of either formal institutional values or substantive political commitments. The continuing battle over the importance and worth of Roe has as much to do with such institutional considerations as with substantive disagreements over abortion. Nevertheless, as great cases like Griswold powerfully attest, when the accumulating pressure of particular substantive values reaches a certain pitch, the conservatism of lawyers will succumb to the institutional wisdom of change and the democratic reputation of the court will depend on transformative innovation, not traditional steadfastness. The demands of judicial integrity are as political, contingent, and contested as any other values. What is required will depend on context and commitment. There are, therefore, no routine cases if by that it is meant that they can be decided in a purely legal and objective manner, that is, by the professional application of pre-existing rules, without resort to political and contingent considerations. Because each case is a potentially great case, all cases have an actual and potential transformative element, it is less that they are of a different kind and more that they are of a different degree. On some smaller or larger scale, all cases transform doctrine or, at least, change it in the sense of advancing or refining it in regard to particular situations. While this insight is by no means novel, its implications for appreciating common law development and adjudication are largely ignored. For instance, in the 1930s, Justice Stone commented that the common law is an evolutionary and variable product, and because every new case has some new factors that require original consideration by the court, every new case is a case of first impression. Accordingly, while the vast majority of cases might appear to be dealt with routinely, they are in fact low-level transformative occasions that do not shake the law's foundations and that confirm that the cut and line of existing doctrine satisfies the present political attachments of judges in that particular situation. For instance, in a consideration of whether Donegal should be extended to auditors, reference writers, and so on, there might well be strong disagreement and dissent. but whatever happens is likely to be in the realm of the tolerable because it will not implicate larger social values. This is clearly not the case with racism, abortion, or euthanasia. Of course, there actually are transformative cases, not merely the ever-present possibility of them. Great cases are those in which the transformative potential is acted upon and legal doctrine experiences a radical reorganization or realignment. In the same way that any scientific change whatever will normally have both something normal and something revolutionary about it, so all legal cases are routine in that they require judges to engage in exactly the same process of reflection on and reaction to the political values that underpin particular doctrinal applications in the prevailing and particular social context. One jurist who has recognized that there are periodic revolutions in the common law's historical development and who has sought to incorporate them into a standard account of the common law's legitimate operation is Robert Lipkin. Although he confines his focus to American constitutional law, he offers a theory of adjudication that attempts to capture the role of the court in sustaining traditions of constitutional transformation through a deliberative method that translates the revolutionary politics of the greater society into workable judicial paradigms. There is much in Lipkin's approach that is enlightening in its willingness to explain the common law process of adjudication through the incidence and importance of great cases. However, behind the pragmatic and critical gestures, it is simply another effort to hijack radical critique and domesticate it for traditional constitutional purposes. It puts a smooth gloss on the jagged workings of constitutional law and politics. Lipkin is very much in the tradition of Dawkinian jurisprudence with his insistence that revolutionary judicial review is self-consciously concerned about politics in the sense of political theory, not partisan politics, and that, when taking society's ideological temperature, the judge's focuses on the constitution and political and moral culture, not on what she personally values and believes. Moreover, his differentiation between routine and revolutionary adjudication is exactly the kind of distinction that the common law's historical development and performance confounds. While there is a difference between routine and revolutionary occasions, it is a matter of degree, not kind. It is most certainly not one of method. All adjudication involves the resort to so-called external and contested political factors. It is simply that revolutionary cases tend to deal with those that are more heated, that demand greater change, and that prevent a more discreet approach than routine cases. It may be that the best of law translates the best of politics into legal form, but what is best in both politics and law is profoundly and irreducibly ideological. For all Lipkin's talk of transformation, his is a very traditional rendition of legal theory. It is a pragmatic tempest in a formalist teapot. Finally, when the emergence and existence of great cases are utilized to support the claim that common law adjudication is political in the sense that anything might go, three important riders have to be offered. The first is that my analysis and critique are jurisprudential. They are not intended as sociological claims about the practical impact of great cases. It is a central issue on the agenda of many social scientists to determine the instrumentality of court decisions on social struggle and conditions. For instance, a topic of considerable importance and debate remains the extent and quality of the effect that the decisions in Brown and Roe had on the practices of discrimination and the availability of reproductive health services in the United States. This debate, both generally and specifically, is beyond the scope of my project. My limited brief has been to tackle the jurisprudential claims of mainstream theorists and to demonstrate that the nature of common law adjudication is more transformative and less traditional in terms of doctrinal development and judicial creativity than is commonly supposed. Any talk about transformation and change is to be treated as a matter of jurisprudential, not sociological, significance. Suffice it to say, however, that the precise impact of judicial decisions will be contingent and contextual. Sometimes it will be substantial and other times it will be superficial. Either way, it will not be possible to generate a general and abstract theory that will be able to predict consistently or accurately what will occur as a result of particular judicial decisions. The social utility of judicial decisions as a vehicle for political change or the political efficacy of courts as a strategic site for social transformation can only be determined episodically and cautiously. The second rider is that, when the common law's development is explained as the interplay of the logical and the expedient, there should be no mistake that, when the logical push comes to the expedient shove, it is the political that will eclipse the doctrinal. As the great cases attest, the bottom line is that, as Hedley Burns Lord Pierce put it, the force and reach of legal principle depends ultimately upon the court's assessment of the demands of society, and that, as Donoghue's Lord Macmillan put it, any proposition the result of which would be to show that the common law of England is wholly unreasonable and unjust cannot be part of the common law of England. Of course, what passes as substantive justice will not be to everyone's liking, but this only serves to underline the contested and political nature of common law adjudication. Moreover, there is no better evidence for that conclusion than the career of great cases. The courts will follow doctrinal logic and formal authority only so far and for so long until political expediency and substantive justice win the day. That includes the fall as well as the rise of great cases. As the fates of Lochner and Roe show, a great case is only great as long as the historical circumstances and political currents support its continued prominence. Once the political winds change, the great case will lose its hallowed status and become one more precedent on the legal scrap heap. Although Donegal and Brown seem unassailable in their greatness, the day could well come when they fall from political and, therefore, legal grace. In Donegal's case, the general consensus around carelessness as the ruling principle in tort might erode and another regime, that is, a more progressive shift to strict liability or a more aggressive move to intentional harm, wins the day. Or, in Brown's case, the public commitment to maintain substantive equality might begin to crumble and a different approach, such as a formal and thinner conception of discrimination, may gain favor. Legal greatness is as eternal or as ephemeral as the political will that sustains it. The third rider is that, because innovation and transformation are at the existential heart of the common law, it does not mean that such innovation and transformation will necessarily be progressive in doctrinal effect. Radical change is not an initiative that is exclusive to the political left or right, insofar as those designations still have any clear orientation. Apart from the considerable difficulty of determining what is progressive in any particular context, the recognition of the judiciary's inevitable role as agents of political activism opens up space in which the law's inevitable political possibilities can be exploited and in which claims that the law is fixed or given can no longer be used to evade responsibility for the actual decisions made. For instance, judges such as William Douglas and Alfred Denning were the most iconoclastic of judges and took a studiedly cavalier attitude to settled legal expectations. Indeed, their greatness was to be found in their innovative and ingenious dexterity with established doctrine. However, it would be silly to suggest that they were progressive in any consistent or committed way. As the history of the common law amply shows, there is no necessary or comfortable relationship between judicial boldness and political progressiveness. Even though this acknowledgement shows that law's transformative character does not lead inexorably to social enlightenment and political emancipation, it does challenge the idea that things have to be the way that they are and, in so doing, opens up space for viable progressive action. No political strategy can eliminate the risk that it might have the perverse effect of legitimating the status quo or the unintended consequence of being regressive. However, society is much less stable and much more volatile than both conservatives, who extol its present justice, and progressives, who rail against its present injustice, allow. It is in a constant state of flux and contains the resources and possibilities for its own doctrinal transformation, albeit in both conservative and progressive ways. Conclusion. In this chapter, I have sought to defend the claim that any account of the common law's development must put great cases at its explanatory heart. When this is done, it is hard to resist the conclusion that the common law tradition is more an open and creative one in which anything might go than a bounded and cautious one. Moreover, the countless efforts by judges and jurists to resist this claim do as much to confirm the political and contested quality of law and adjudication as to deny it. Indeed, one of the few constants in law and adjudication is that change and stability are maintained through continuous acts of revision. Transformation is the lifeblood of the common law's vibrant tradition. Faced with this situation, academic commentators and judicial participants are given a Hobson's choice. On the one hand, they can recognize great cases as routine illustrations of how the common law develops incrementally and logically. This is a stance that most reject because, among other things, it would make it extremely difficult to explain why great cases were in any way great. On the other hand, they can concede that great cases are radical instances of how the law develops by breaking with its past. This is a stance that most reject because, among other things, it confounds the idea that the common law develops incrementally and logically. Accordingly, any acclamation of great cases is also a celebration of the critical insight that law is politics. To be in praise of great cases is a tribute to the force of the observation that continuity with the past is only a necessity, not a duty. In addition, judging from the history of its development through great cases, the common law has and continues to impose a duty on its personnel to respect the past best by revolutionizing it in regular acts of continuing transformation. As the next chapter shows, as a hermeneutical supplement to Darwin's evolutionary insights, the work of Hans Georg Gadamer captures much of why that duty is imposed and how it can be satisfied.